So, good day, ma'am. This is my entry of my video examination about criminal law. So, Article 3 is all about felonies, and felonies are committed not only by the means of deceit but also by means of fault. Deceit is a dishonest behavior, and it will appear when the person or offender acts or performed the actions with intentions. Like, for example, the offender takes time to plan the crime or the situation so that it will be successful. And there is fault when the crime is not planning and it execute or perform with a lack of skills. In the Article 4, it is all about criminal liability, where it shall be incurred when someone perform an action or offense that is against a person or the property. A criminal liability talks about a person who is liable for the crime or responsible for the crime which he or she acts or commit criminal intention, which means a person who commit a crime is criminal liable for breaking the law. So he or she may be held legally for breaking the law. So a felony is consummated when all the elements necessary for its executions and accomplishment are present, such as when you hit the victim with a hard wood and killed him. That's an example and can be considered as a consummated felonies. And it is frustrated when the offender performs all the actions that will produce a consequence, which is a felony, but the reason or the cause of the crime is not produced by the offender's will. Like, for example, a person stab the person he or she hate the most with a knife without knowing that that person that he stabbed or she stabbed is already dead minutes ago by the hit of gun, by a shot of gun in his back, which the offender thought that he is the reason why that person is die, and that will be considered as a frustrated. And lastly is the attempted felony. There is an attempt when the offender tries to do a crime but did not perform it well or did not finish it due to something distractions or reasons. Like, for example, when the offender tries to rape the victim but he could not finish it or perform it or do it because someone is coming or someone is arrived, like, for example, police officers or any strangers, that can be a distraction, and that can be the reason that he will not continue to do the crime he attempt to do. So that is an attempted felonies. So justifying circumstances are the situations that a person has a chance to justify his or her side for doing the crime just to save themselves. They do the crime because they need to. And, like, for example, a self-defense is belong to the justifying circumstances because he just commit a crime because he needs to protect herself or himself. That is why it can belong to the justifying circumstances. And in justifying circumstances, there will be no criminal liability in the offender. The next is exempting circumstances. From the word exempting, there will be an exemptions. And these circumstances are the situations that needs to be exempted because there are conditions or something like disease that the offender feel or have while doing that crime, to the point that when he commit the crime, he didn't know what he is doing, or he is lack of intelligence during the time, and he didn't know that it's already a crime. And for example, an offender has a mental illness, and all that he or she wanted to do is to get things from other people, from other like for example stores and company, and then there are exemptions on the punishments on that offender because he has conditions that needs to be exempted. Third one is mitigating circumstances. This circumstances serves to reduce the penalty of the offender, and of course they are basing on the situation. And in these circumstances do not excuse or justify an offense but take considerations. And last is the aggravating circumstances. Unlike the mitigating circumstances, aggravating is to increase the penalty of an offender, because in the mitigating circumstances it will reduce the penalty or the punishment, but in this aggravating is to increase the penalty or the degree of liability. So the principals is the one who execute the crime, or the master of the crime, or shall we call it mastermind, and he or she is the one who carried out the crime, and while the accomplice is the one who helped the principal to make the crime success, or the accomplices are more connected to the crime itself than accessories, because the accessories are usually the people who cover up the crime after it has been committed. Or we can say that accomplice is present and usually have an integral part of the crime in the criminal act, while the accessories are not present at the time that the crime is happened. The penalty of reclusion perpetua shall be from 20 years and 1 day to 40 years. Any person sentenced to any of the perpetual penalties shall be pardoned after undergoing the penalty for 30 years unless the chief executive will decide that it is unworthy to have the pardon. Reclusion temporal. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. Prison mayor and temporary disqualification. The duration of the penalties of prison mayor and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, because it must be the duration of the principal penalty. The duration of penalties of prison correctional, suspension, and destierro shall be from 6 months and 1 day to 6 years, except when suspension is imposed as an accessory penalty, in which case its duration shall be that of principal penalty. Aristo Mayor, the duration of the penalty of Aristo Mayor shall be from 1 month and 1 day to 6 months. The duration of penalty of Aristo Minor shall be from 1 day to 30 years. So, pardon is normally granted after a person has served his or her sentence. A pardon is an expression of a precedent forgiveness and typically is granted in recognition of the pardon. Applicants applicants' acceptance of responsibility for the crime he or she committed. It is also a recognition of established good conduct for a significant period of time after conviction and completion of the sentence. Commutation of sentence is a reduction of sentence currently being served. It is a precedent's decision to commute a sentence that does not eliminate a federal conviction. It doesn't imply that a person was innocent for the crime that he committed or convicted, nor thus it removed the ramifications of a criminal conviction, such as losing the right to vote. So, the offender just reduced his sentence, but he's still not freely like in the pardon. So, amnesty is granted to classes of person or community who may be guilty of political offenses, generally before or after the institution of the criminal prosecution and sometimes after convictions. So, in short, commutation of sentence is a reduction of sentence, and the pardon is granted to a person who has already been convicted, while the amnesty is extended to the person who are subject to prosecution but not yet convicted. So, recidivism is an act of a person repeating an undesirable behavior after they have experienced negative consequences of that behavior, or they are rearrested with a similar offense. Habitual delinquency. From the word habitual, you can say that it's their habit to do the crime even after how many years they convicted of a serious crime, or when they do crimes for the third times or more, and they will be considered as habitual delinquency because we just did the crime not just twice but thrice and more. And quasi-recidivism, in this situation, the person or the offender commit another crime while he or she is still convicted by final judgment or still facing the sentence that he or she have, but do another crime without finishing the first one. The recidivism, habitual delinquency, and quasi-recidivism are somewhat similar because they do a crime more often, yet they are different in every situation, and the imposing of penalty will increase or more complicated because they commit more crimes. So the difference between complex crime and compound crime is that a compound crime is only a single act, but there are a lot of crimes being produced. For example, Samantha burned the house of Hera, maybe because of jealous, which result the death of a lot of people inside the house of Hera. It is a compound crime because there is only one action, which is burning the house, but there are a lot of people affected or died in that just action, one action. While the complex crime is committing offense to cover another offense. Like for example, Jonas and his team robbing a bank that have a money worth 300 million. And the police arrive when they are still in the bank, inside the bank, so that they will do another offense, which is robbing, which is hostage. They hostage the people inside the bank too. They staff of the company and then the other customers. So it is a complex crime because they make an offense, which is the robbing of the bank. Then, to cover it, they do another offense, which is the hostage. They hostage the people inside it. So, criminal liability may be extinguished either totally or partially. It is totally extinguished because of, first, the death of the convict or offender. So the criminal liability of the offender, which is already dead, is extinct. Second is because of the service of the sentence of the offender when the offender or the convict finish the sentence that he have. Third is by amnesty, which completely extinguish the penalty and all its effects. Fourth is because of the absolute pardon. Fifth, by the prescription of the crime. Sixth, by the prescription of the penalty. So the 6 reasons that I've said are the reasons why the criminal liability of an offender is extinct, because when the offender is died, then his or her criminal liability gone, since he or she is not alive, and the others because of pardon and completing the sentence, because when you get out in the jail or what, with the proper process or papers, then the criminal liability of an offender or convict will extinct. Thank you so much, ma'am, and that's all.